1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်223 HD AHUJA and others plaintiff versus PC GHOSH deceased represented by his wife Dorla Yin and daughter defendant ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Reference Before Uttarphe Judge HD AHUJA and others plaintiff versus PC GHOSH deceased represented by his wife Dorla Yin and daughter defendant. Suit for recovery of money due on accounts taken, balance sheet prepared by a qualified accountant, failure to point out its incorrectness, no proof of irregularity or erroneous, whether sufficient to attach liability on the defendant. Hell, the defendant PC GHOSH was a working partner in the partnership business and was therefore asset to the account book of the partnership firm. The balance sheet prepared by Mr. A.S. Hakim was incorrect. He should able to point it out either to Mr. Hakim or to the court. This he had failed to do. There is also nothing on the record to show that the balance sheet prepared by Mr. Hakim, a qualified accountant, either irregular or erroneous. Under these circumstances, the defendant PC GHOSH cannot be allowed to say that the balance sheet prepared by Mr. Hakim is not sufficient to attach liability upon him. Dogame and others versus Sunamran and others AIR 1944 Lahore page 58 refer to R. Basu for the plaintiff, Tema for the defendant, Uttarphe Judge. This is a suit for recovery of Jet 51,743 92 Pia due on accounts taken. It is the case of the plaintiff that they and the defendant PC GHOSH carry on the partnership business under the name and style of Massa AHUJA Radio House at number 126 Sule Bagoda Road and AHUJA GHOSH and Company at number 254 264 Bar Street, Rangoon, that the capital of the partnership business was Jet 100,000, to which defendant PC GHOSH contributed Jet 26,428, that one of the clauses of the partnership deed provided that the net profits and losses after payment of outgoings shall be shared or borne by the partners according to the amount of capital respectively subscribed by them, that the partnership was dissolved by mutual consent on the 1st June 1959 by a deed of dissolution by which the partners agreed to go into and accept the partnership accounts outstanding on the 31st May 1959, that ongoing through the accounts it was found that the defendant PC GHOSH had to pay jet 29,491.83 piastres, being the amount he had overdrawn and his share of contribution to the loss incurred by the partnership business for the period ending 31st May 1959. That the defendant P.C. GHOSH was also liable to pay income and super tax amounting to jet 9,398 rupiah for financial years 1946, 1947 to 1953, 1954, and also jet 9,759.88 piastres for financial years 1954, 1955, and 1955, 1956. That the interest payable on these amounts from 31st December 1959 to 30th January 1962 was jet 3,094.19 piastres, thereby bringing the total amount to by the defendant P.C. GHOSH to jet 51,743.92 piastres. The defendant P.C. GHOSH filed a written statement by which he denied the correctness of the amount claimed by the plaintiff and further contended that the suit against him was not maintainable inasmuch as the partnership was not registered, that the partnership still subsisted as he was compelled to sign the deed of dissolution by reasons of coercion, threat, misrepresentation, and fraud, that the suit against him was barred by limitation. During the pendency of the suit, the defendant P.C. GHOSH died and his wife and daughter were brought on the record as his legal representative. One of the plaintiffs, namely M.T. AHUJA, was declared an insolvent and the official receiver was accordingly substituted in his place. On the pleadings filed by the parties, my learned predecessor joined the following issues. Issues 1. Was the late P.C. GHOSH compelled to sign the deed of dissolution of partnership under misrepresentation, fraud, coercion, and threats practiced by the first plaintiff? 2. Is the suit not maintainable for want of registration of the plaintiff fund and of the partnership deed and for the allegations made in paragraph 1 of the written statement? 3. Is the claim against the defendant barred? 4. Is the amount jet 51,743.92 piastres claimed by the plaintiff as shown in paragraph 6 of the amended plain correct? Issue number 1. The burden on this issue is on the defendant, but there is not a shred of evidence to substantiate the allegation that he was compelled to sign the deed of dissolution by coercion, threat, misrepresentation, or fraud. In fact, none of his legal representatives had chosen to go into the witness box in support of the defendant's allegation. The issue must therefore be answered in the negative. Issue number 2. Since the plaintiff had produced the deeds of registration of the firm Exhibit X and 1. The contention regarding non-maintainability of the suit for one of registration cannot be sustained. This issue will be answered accordingly. Issue number 3. This issue has not been pressed by the learned advocate for the defendants at the time of hearing, the suit having been instituted within 3 years from the date of dissolution of the partnership business is clearly within time vide Article 106 Limitation Act. The answer to the issue will therefore be in the negative. Issue number 4. The learned advocate for the defendants strenuously argued that the plaintiff claim, having been based mainly on the balance sheet prepared by Mr. A.S. Hakim, could not be said to have been proved against the defendants. He submitted that the accounts prepared in the ordinary course of business are admissible in evidence, but such accounts cannot form the basis of defendant's liability unless there is evidence to show that the defendants have in any way admitted its correctness. I have no quarrel over the proposition that under Section 34, Evidence Act, the entries in the account book kept and prepared in the ordinary course of business by itself do not prove the liability of a party to the suit, but in the present suit, it must be borne in mind that the defendant P.C. GHOSH was a working partner in the partnership business and was therefore accessible to the account book of the partnership firm. If the balance sheet prepared by Mr. A.S. Hakim was incorrect, he should be able to point it out either to Mr. Hakim or to the court. This he had failed to do. Besides, the exhibit documents A and F clearly indicate that the accounts of the firm had been gone into by Mr. A.S. Hakim with the joint consent of the defendant P.C. GHOSH and the first plaintiff H.D. AHUJA. There is also nothing on the record to show that the balance sheet prepared by Mr. A.S. Hakim, a qualified accountant, is either irregular or erroneous. Under these circumstances, the defendant P.C. GHOSH cannot be allowed to say that the balance sheet prepared by Mr. A.S. Hakim is not sufficient to attach liability upon him. In this connection, it will be relevant to refer to the decision in Dogame and others versus Sunamran and others 1, where it was held that the partnership account book, being accessible to all the partners and being kept more or less under the surveillance of them all, are prima facie evidence against each of them, and therefore also for any of them against the others. Consequently, in a suit by some of the partners against the others, it is not open to the defendants to ask that the partnership account book relied on by the plaintiff be formally proved or to contend that they were not prima facie evidence against them. I am therefore of the view that the defendant P.C. GHOSH owned jet 29,491.83 pairs to the plaintiff for the amount he had overdrawn and for his share of contribution towards the loss of the firm as regards the amount of income tax which the plaintiff had claimed from him, namely that 9,759.88 plus that 9,398 2 plus that 19,157 19 plus there is an admission by the plaintiff that a refund of that 19,650 12 plus had been benefited by the firm vide Exhibit L, which was not available at the time when Mr. A.S. Hakim went into the accounts and was therefore not taken into consideration by him when the balance sheet was drawn up, since the defendant P.C. GHOSH had contributed that 26,428 towards the total capital of that 100,000, he is entitled to a sum of that 5,193 10 plus out of that 19,650 12 plus the entire amount of refund of income tax. Thus, the total amount owed by the defendant P.C. GHOSH to the plaintiff was that 48,649.73 plus minus that 5,193 10 plus that 43,456.63 plus interest on that amount at 3% per annum for 2 years and 1 month will come out to that 2,716.68 plus the gross amount payable by the defendant P.C. GHOSH is therefore that 46,173.31 plus. In the result, there shall be a decree for that 46,173.31 plus in favor of the plaintiff with proportionate costs against the defendants.